welcome to today's training seminar, which, as you can see, is around data protection, our good old friend GDPR, and data breaches. Very conscious that for the vast majority, probably of you on the call, this is going to be a refresher. GDP's been with us for a while now. It's something that's not just applicable to financial services, of course. So we experience being on the other end of it, so to speak, as consumers, the most visible sign of which is when we're surfing on the web, being asked if we agree to the cookies or not, which is all part of the new GDPR regime.
That we're all on it.
So today's session focuses on the regulatory context for the use and protection of data, and with a fair wind behind us, we're aiming to finish no later than 11 o'clock. If we can bring it to conclusion any sooner than that, I know you're all busy, we will do that. Please, at the end, if you could just stay online. So Charlie's got some admin he needs to do in the background just to make sure that we can get CPD certificates to you. So if you just bear with for a minute towards the end until Charlie tells us he's got everything that he needs in terms of attendees to make that happen and take some of the strain away from you from an administrative point of view. The only other thing I'd say from a housekeeping point of view is that when we were together last week, we had a great session together. Some people were kind of, because it's the real world and clients are phoning, are taking phone calls, etc., which was disrupting the training for other participants. So if I could please ask you to make sure that you're on mute. By all means, if you want to ask questions as we go along, please chip in. I'm not saying don't participate in any way, shape or form, but if somebody's on the telephone having we can hear a one-way conversation with the client. As I say, it was a little bit off-putting to some of the other delegates who were on the line. Good stuff. Right, so let's get underway then, and let's just start by just contextualizing where we are today. So it's almost impossible, I guess, to live, work, socialize without generating data. And as they say, data is the new oil. If you think about the profits that technology companies are making, such as Facebook, it's all about what they're doing with our own personal data. So the government and the authorities have decided that individuals should have the right to, in the first place, understand how their data is being used and also give them the right to access that. That was beefed up under GDPR. Also, that consumers need to take an active role in giving consent for their data to be collected. And we'll look at how that manifests itself in a practical sense as we move down the session. And also that consumers have guarantees that their data is being treated confidentially, with respect and with discretion. So consequently then, when dealing with our clients, we all now have a duty to explain to them in detail what information that we're seeking from them, indeed why we're seeking that information, and what we intend to do with it. Broadening that out, who else apart from ourselves may be involved in providing services to them. So for those of you who use third-party services, you'll be aware of the requirement to do that. And they need to be informed about how the information is going to be stored, how you're going to take steps to ring fence and secure that data. And in the event that data needs to be transferred, how the safeguards and checks and balances are in place for that. And when information will be deleted if it's no longer required. So that's kind of the contextual piece in terms of what's informing and driving data protection and GDPR. In terms of what we're looking to achieve this morning by way of our learning objectives, we've done the first one in terms of trying to contextualize data security. We're also going to, again, refresh ourselves on some of the key terms around data protection. We'll look at the differences between personal and sensitive data and some of the ramifications around that. We'll then do a deeper dive into GDPR and look at the key elements and principles of GDPR. And most importantly, from our perspective, I guess, as advisors, is to make sure that we're going to be compliant under this GDPR regime. And then if the worst happens and we do suffer a breach of personal data, then we're fully aware about how steps we need to put in place to report that to the ICO and the timeframes that are wrapped around that. It's also necessary, I understand, for IFAC members to go on and then take a test, a data protection test, which is on the VAT system. I'll reference that again towards the end of the workshop. Charlie and the team have kind of beefed up the exams for this year. I went on and did the test myself yesterday. It's now 50 questions long, so it's been expanded. But please be assured that what with attendance on this seminar and the support materials that are available, more of which later, you'll be in very good shape to be passing that exam at the first time of asking.
Sorry, Jeremy, quick thing. Also, I will be puntualizing some of the things that we will need to protect our data. I'm Álvaro González, cybersecurity head of Bad Software, the software that we are using. And yeah, if it's really important, as you say, Jeremy, about all this regime of the GDPR and the problems that it is generating with the new FCA points that they've been came out like a few months ago, and there is a lot of people with these worries. So I think getting in deep in these areas, it will help a lot, and also with the test that we will that is already in IFAC, it will be really helpful for those that they need a little bit of guidance.
Okay, that's brilliant. So at any time, you just chip in, absolutely fine. Yeah. Okay, brilliant. Thanks so very much. So let's start just by understanding what data protection actually is all about. And in essence, it's about avoiding harm to individuals by misusing or mismanaging their personal data. So in our kind of profession, we use and we store personal data, so the Data Protection Act is going to apply to us. And as you know, what it does, it controls how personal information is used, and it means that we all have to be aware of something called the data protection principles and follow those rules. You know, they're not an option, they're things that we have to do, enforced by the power of law of the Data Protection Act. So as I say, we're all kind of used to working in this environment now. So in terms of what constitutes personal data, well, it's any information about a living individual which could be used to identify that individual. So as you can see, this is the kind of the more routine information like contact information. There's the first sight again of things like those online cookies that could be used to identify an individual. And I think we're all kind of well used to these descriptions and definitions now. As we know, there's also a category of data that's regarded as much more sensitive because of the nature of the information, as you can see on the slide there, it could mean that people are able to form biased opinions about someone and discriminate against them. So as you might imagine, there's much stronger legal protection for the more sensitive information over and above the protection that's in place for personal data. So I'm not going to go through them line by line. You can see where the kind of line is drawn between personal and sensitive for what I think is very obvious reasons. In terms of, again, just refamiliarizing ourselves with some of the key terminology that comes up from data protection. At the top of the pyramid, I guess, we've got the data controller. So the controller can either be a person or a firm who has ultimate responsibility for complying with the Data Protection Act and determines how any personal data will be processed within the firm. So that's clear, I think. In terms of data processors, that would be any individual who uses data on behalf of the controller. So it's typically going to be members of staff in or connected with the firm, maybe third parties who you work with who act on your behalf. The data subject, I think, is fairly self-explanatory. That's the person about whom the personal data is being processed and held. And personal data processing is basically just anything that we do with or to the personal data of the data subject, and that would include storage of their personal data. Now, in terms of formally requiring a data protection officer, it's a specific role, and for some firms, it's a legal requirement. So this will depend basically on the size of your business. Hopefully, for the majority of us, it won't be required because it's for firms who have got more than 250 employees. There's a legal requirement. Sorry, do you want to come in now?
Yes, I will also add a term of personal data breach. Even though the term is really self-explanatory, it's part of the vocabulary that you will find in the GDPR or in other terms of conditions that is involved data protection. I think it would be also beneficial that that people know about the personal data breach.
Yeah, data breach. Yeah. Okay. Well, we'll be looking at breaches later on in the session. Yeah. In terms of the storage and security of data, then the data controller is responsible for the secure storage of information, and that's whether or not it's paper or electronic. I mean, I'm old enough to remember the filing cabinets around the office with the client files and all the documentation in. I think these days, largely, we're all in the electronic world. Each firm is responsible for ensuring that you can't allow unauthorized access to the computer records or indeed the paper files. So that's, again, in terms of information security and data security, I think that's something that we're all more than consciously aware of. So in terms of, general data protection measures, what do we need to do? Firstly, we need to protect it. So as soon as possible after we've collected it, we need to make sure it's secure. If any data gets stolen, that would be a breach, or we accidentally lose it, that would be a breach. In terms of making sure not only that it's secure, but it's kind of encrypted or locked away. Again, because of my age, I can remember going around the office and locking up the filing cabinet and desk drawers at the end of the evening. These days, it's about making sure we've locked it digitally in our digital space. And as soon as we no longer need the data, then we should be looking at how best to destroy it, but obviously destroying it in a secure way. Yeah. So if the data is being passed on to a third party, I know for that, some of you on the call, you will be working closely with third parties across a variety of different pieces, then the subject should have provided permission for that data to be shared with the third party. And I know from the work I do with advisors, that's kind of well baked in to things like your privacy notices, etc., that you use on a day-to-day basis. I've referenced the Data Protection Act a few times now, and actually data protection goes back quite a way. It first became law, believe it or not, way back in 2098, but the most recent General Data Protection Act is indeed 25th of May 2018, and that's a key act because that was the act that also implemented GDPR. So that's the act that put the EU directive which onto the UK statute book. So obviously the EU gave a directive in terms of how personal information was going to be used. It was also about beefing up individual rights, privacy obligations, promoting individual rights to their personal data. If you were to look at the GDPR regime, it's got actually 99 articles contained within it, but few, only 7 of them apply to UK financial services. So as I say, going back, data protection, GDPR, it's much broader than financial services. It covers every kind of trading entity and everybody who handles personal data in the UK. And as such, it's not regulated directly by the FCA. There's another regulator, as you know, called the ICO, the Information Commissioner's Office, whose sole responsibility is to enforce the GDPR and data protection regime in the UK. More about them later when we talk about breaches. So in terms of GDPR then, let's have a look at this, what the main differences are now that's come into place. So as I say, the first thing that GDPR did in summary is to make sure people have got much greater control over their data and how it's processed. It also put an obligation on firms to evidence that they know and understand about data protection procedures and that they are implementing them on an ongoing basis. It also requires firms to be much more transparent about the ways in which they use customer data in order to deliver services to them. And it does impose much stricter rules about disclosure of data breaches, more of which towards the end of the session. But it is worthwhile us knowing and understanding the implications of this, because even if unwittingly we are non-compliant, then under the GDPR regime, you know, we can get some quite hefty fines. Yeah, it's actually a 20 million euros fine, or 4% of annual turnover, whichever is greater. You know, as you've seen from, you know, reading the press, from time to time, companies normally inadvertently have fallen foul of this, and they've picked up some quite swinging fines. Just to give you a feel of the kind of the delta, under the old Data Protection Act, the maximum fine was £500,000. Under the new Data Protection Act, which implemented GDPR, which is say 20 million euros. Last time I looked at the exchange rate, was around about 17 million quid. So quite a delta between the two. In terms of the main aspects of GDPR, what you've got is one overarching area, which is accountability and governance. And then beneath that, you've got 6 sub areas, such as strengthening individual rights, personal inventory data, consent, suppliers and third parties, privacy notice, data security, and breach notification. And what I'm going to do is I'm actually going to walk through each of those 7 areas now in a little bit more detail. So just lift the bonnet a little bit and have a look at the key points of each. So if we start off with accountability and governance, as I said, this is an overarching theme under which the other subcategories sit. And basically, in summary, what it's saying is that data privacy needs to be integral to a firm's way of working. And it needs to be applied not just to clients, but to employees and, if necessary, shareholders as well. So it just needs to be kind of baked in to our processes and day-to-day trading. The other thing it says is that all staff need to have been trained and be aware of their responsibilities under GDPR. So again, just to reiterate, Charlie's congratulations when we kicked off. Well done on coming on to this workshop I know that some of you will take this session and cascade the information down to your staff to make sure that they are refreshed with their knowledge and understanding of responsibilities under GDPR. So well done on that. And just while I'm thinking about that, the video of this session, if you want to use that for your training, will be available on the BAT system from Monday afternoon. The other thing that it requires us to do is to actually have looked at our business and done a risk assessment, basically. So have we assessed the risk of potential data breaches, and what are we doing to mitigate and reduce the likelihood of breaches, which means that we can protect the individuals, the clients that we're working with, and protect them as far as possible from harm through breaches or misuse of data.
Yeah.
Do you want to jump back in?
Yes, these are really key factor, not only from all the personnel of the company, but also is really important to make sure that the IT teams, also cybersecurity teams, are on top of this priority. A lot of the times, the IT department or the cybersecurity department is overlooked like a luxury into a company, but nowadays it's one of the most critical and key components to have and to ensure the protection not only of the network and the equipment that you have, also this data that is really important. As you said, there is like heavily really big fees if you don't make these points. So it's a really connected work with all the departments, but mostly the IT department and the cybersecurity department of your companies, they should be on top of it 24/7.
Yeah, absolutely.
Yeah.
Brilliant. Well said. In terms then of strengthened individual rights, as you know, this is one of the key things that came out of GDPR. Big piece around access. So the right to know, all consumers in or outside of financial services have the right to know what information firms hold on them digitally and on paper. And they have the right to submit something called an SAR, a subject access request, to actually look at the information companies have got. So, in writing. And if anybody, any client asks you for their information, submits an SAR, then you must provide it to them without delay. But the deadline is at least within 1 month of receipt of the request. And you must make that available for free. Yeah. You could charge, if you were minded to, the cost of covering the administration. But my experience is that most firms would look to do that for free of charge. In terms of rectification, if as a result of an SAR, they believe that either their data is incomplete or inaccurate, they can ask you to put it right. And once again, it's good to remember that you need to action that within 1 month. There is possibility of an extension to that 1 month timeline if you think that their request is manifestly unfounded or excessive. So in other words, they're asking you to do something that's going to take a whole rump of work and you can't quite figure out why you need to do that. They also have something called the right to be forgotten, and they can actually do that in writing. They can do it verbally, or increasingly, companies I'm working with, there's a facility to do it via social media. Again, got 1 month to respond to a request. Now, that's not an absolute right. It only applies in certain circumstances. There are some situations where you can't erase the data because that data is required for certain purposes. If you want any more information on that, as I say, there's some excellent support materials on the BAT system, including a link directly to the ICO's kind of guidance on ICO. It's well worth a read if you've not looked at that for a while. The other big one is the right to object to data being used, particularly if it's being used for direct marketing purposes. And here you do have to be out the blocks much more quickly, because if somebody objects to their data being used specifically for direct marketing, you have to stop doing that immediately you receive that request. No exemptions to that, no grounds to refuse, just need to get on and do it.
Yeah, as Jerry said in the right to object, there is some questions about it. But for example, taking the example of Facebook, when you sign the terms and agreements to enter into the platform, they said that the data is subject to be used as a marketing, or like to be traded as a marketing object. And even though in your terms and policies you specify that the individual has the right to be opposed to that, and even though they sign the rights or terms, it's not exempt of that. I wanted to make that clearly because it was a huge dispute in Ireland with the tribunals with Facebook about this subject, and in the end, Facebook lost paying a massive fee.
Okay, but that's good to know, because I'm sure some of you built that in to your terms and conditions, but that doesn't necessarily give you the protection maybe you thought
Exactly.
It did. Yeah,
exactly.
So the rights of the consumer, I guess what we say is under GDPR are supreme. This is all about consumer protection.
Correct. Sorry, I'm correct. I'm more in Europe and subsidized in the UK, because most of the GDPR, as you said, came from the GDPR from the United Union, and in America and other countries is a completely different topic. But under the umbrella of the GDPR that we have now, and also in Europe, is completely the consumer has the complete right, even though they sign the terms and conditions.
Okay, brilliant. Which is probably aligned to what we know and understand with things like consumer duty, etc. So consumer, clients are primary, and we're there to serve them, I guess. In terms of information that firms must provide to individuals under these GDPR, we need to let them know which of their personal data is being stored, why we're storing it and how it's going to be used, and also the lawful basis for processing such data, which again, I know from my work with advisors is kind of well baked into our privacy notices and processes. If we move to the next element then, underneath that overarching accountability and governance, there's a category called personal data inventory. So this is where there's a requirement on you to detail what personal data you're processing, the reasons behind it and the lawful basis supporting it, where the data is being stored, whether any third parties are processing data on your behalf, and which data requires consent and which does not. And I know from my exploration around the BAT system, again, some excellent materials on this in terms of how IFAC can support you in terms of creating this personal data inventory. And I'm sure they're kind of alive and well in your respective businesses. And the next category is around consent. So the personal data inventory is important because it enables us to track which data requires consent and which does not. Yeah, because consent isn't always required for data processing on a macro level, but typically in our industry, it probably is required. Where consent is required, it must be given in the definition of the GDPR directive freely. It must be specific, informed, and unambiguous. What does that actually mean in practice? Well, in practice, what that actually means, it must be opt-in rather than opt-out. So you have to get clients to actually tick boxes either on paper or digitally. We can't just say, by not ticking that box, you've kind of given consent. It's the other way around. You have to tick the box to give consent. Now, as consumers, as I say, you'll see this is going well outside of the financial services arena. It's become baked into the processes of every company that processes and holds personal data, so that you have to go in there and proactively give consent and opt in rather than opt out. And the key thing is that we can't pre-tick boxes, so that's not acceptable. Or we can't say, you know, just by doing nothing, that's you've kind of tacitly given your consent. So we've moved from reactive to proactive, from tacit to kind of explicit permissions, if you like, regarding consent around personal data. As I say, I think I'm right in saying that many of you would probably use third parties in terms of support services within your business. So you must be aware of any third parties and the way in which they're processing personal data on your behalf, because under GDPR, it's you as the firm who are holding the contract who's actually accountable for the actions of your third party data processors. So, you know, they're not totally off the hook. You know, the data processors have legal obligations too. So this is why it's vital, and I'm sure you've got this in place, that you've got a good contract drawn up between you and any third party data processors to make sure that, you know, everything is aligned and as it needs to be. Yeah. You do have some recourse against the processor in certain situations, breaches or non-compliance, the GDPR rules. But I guess my kind of counsel is, let's not let it get there. Let's make sure our contracts are robust and that each party is totally aware of and signed up to their respective obligations.
Mm-hmm. It will be you will have some exceptions if the third company is being hacked, not in terms that they misuse data, but for example, if they use, if they are suffering an attack, for example, engineering attack that it gets granted to credentials, and then they are access to that information, even though it is true that you have to be aware with the people, with the companies that you are working, as Jeremy said. There are some cases and some exemptions. If you have the knowledge that this third party is you know that they are not managing the information correctly, you're gonna be subject of the same fault. But in case of, for example, they have a DDoS attack and all the data goes down, or they gain access to a certain areas of data, and the third party has shown that they put all the efforts to protect from that, then you are the same in that case.
Brilliant. So in summary then, if it's day-to-day business processing, they're kind of on the hook. If it's cyber attack or something similar,
exactly,
then there's some discretion.
It is some discretion, but the key part there is that the third company has to prove and show that their systems, they've been actively protecting it, and there was a vulnerability there that
it's a breach despite the protection they put in place.
Exactly.
Yeah. Okay. Brilliant. Yeah. Thank you for that. Right. So, in terms of the final element underneath, you know, the seventh element, that's all about data security and breach notification, and we've got a specific section on that because it's so important later on in the session. In terms of subject access requests, mentioned those earlier on, this basically gives individuals the right to, as I've said, access and receive a copy of their personal data. And they can do that in any way they choose to do it, and, you know, the right to receive a copy of it. They also get the right to be forgotten. So if you no longer need the data, then they have the right to say to you, I don't want you to hold my data any longer. Now, in a robust kind of environment, if you didn't need the data, you would have been deleting that anyway. In terms of requirements on firms, then, as I say, you can't really charge the client a fee to access the data other than the reasonable administrative cost of providing that information. I mean, that's what the rule says. I say in practice, 99.9% of firms wouldn't dream of charging a client a fee for access to the data. The other key bit of information that you need is that when you do get a subject access request, then you must, within a month of receipt of that request, actually provide the information to the client, to the consumer who has made the request. You have to do it in a way that is accessible, concise and intelligible. So you can't bombard them with a load of Excel spreadsheets or things like that. You must package it up so that a reasonable person would be able to understand the information that you've provided to them. And what is key is that you disclose the information securely. Now, when I spoke earlier, I said that some firms had actually been fined under the GDPR regime, and at least 3 of the fines in the last 48 months that I can recall are to do with that final report, that they were trying to do the right thing in terms of sharing information with the client, but they hadn't taken reasonable steps to make sure that information is securely disclosed. So this is about encryption mechanisms or supplying passwords to enable a client to actually access their own information. In terms of those of you who are sitting there thinking, right, well, this is kind of whetted my appetite, if you like, in terms of thinking we might want to just revisit our compliance with GDPR and making sure that everything as it should be. Is a kind of a checklist of things that you might want to think about. It's not designed to be, totally all-encompassing. It's just a kind of a starter for 10. And as I say, if you look on the BAT system, there's much more help, guidance, and support available to you on there. So the first thing is, in what way are you providing that privacy notice to your clients to inform them of their rights? When's the last time you redrafted that privacy notice? Are you very happy that it's still fit for purpose and meeting all the requirements? How do you think it would land with the client? Have you done any kind of testing with that to make sure it's as easy to understand as possible? Carry out an information audit, do a personal data inventory, detailing why you've got each piece of data that you're storing. So what are the legal grounds for you having that information? Yeah. Check which data requires consent to ensure that the consent meets the requirements of the GDPR. So have you got the right consent? Remember, we said it has to be not ambiguous, be very clear. And if necessary, what do we need to do to revisit some of that? If you've got any data where a client hasn't given their express consent, then it should be deleted. I think that would be unlikely, but nevertheless, wouldn't hurt having a look, even just to demonstrate that you've done an audit and that you're concerned about these things. I've talked again about working with third parties, so just revisit those contracts. Think about Alvaro, what he said in terms of, yeah, you might have it in a contract with them, but just make sure that you are covered in the event of a cyber breach from a security point of view. Ensure procedures are in place to manage and report data breaches. Now we'll talk about that more in a moment, but I guess that's something that needs everybody within the business needs to kind of know and understand. And I guess that's going to be part of your training and upskilling of your people. And when and if somebody does submit a subject access request, how are you going to go about fulfilling that request so that it can see their personal data? Because it's not something that happens very often in my experience. You know, that's relatively rare event. Just because it's a rare event doesn't mean that we don't need to have a process in place to say, okay, if that's happened, how can we get that together and get that back to them within that deadline of a month, but hopefully we'll exceed that and get it back to them just as quickly as possible without undue delay. So I've been kind of profiling the fact that we're coming up to data breaches, and here we go. So, you know, I'm hoping that for the vast majority of us on the line, we'll never actually get in a situation where we have a data breach. But if we do, it's best to know what needs to happen. So, as you will recall, under that GDPR regime, one of the key elements was, you know, data breaches that introduced a duty to report certain types of breaches to what was called the relevant authorities. So in the UK, that would be the Information Commissioner's Office, the ICO. So under the GDPR definition of a personal data breach, it's quite broad, as you can see there. So any breach of security which leads to accidental, unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. So a very broad definition. I'm going to let Alvera jump back in here.
This is quite challenging for cybersecurity teams and IT teams, because as Jeremy said, the definition is so broad that categorizing like a cyber attack to see if they have some breaches of data is really difficult. Like, for example, let's gonna put a practical case. An attacker gain access to your website. It doesn't need to be the files or anything, but it's the website. That would be considerable a data breach. Yes and no. Even though it accesses and has some data from the servers and also from the website, you have your teams and you have to assess if it's vulnerable data, as we said previously, or if not. And in case of doubt, please contact with the ICO, and it's better to it's better to report these kind of things, even though doesn't mean that it's a proper breach of data, but just in case, because this, as Jeremy said, the definition is so broad that you are never 100% sure if it's gonna be important data, or the ICO is gonna consider it as an important breach of data.
Yeah, absolutely. So I think any inkling of a breach, report it. Doesn't matter if you don't need to, get it reported, and then you've covered, you know, you've met your obligations in terms of, you know, fulfilling your responsibilities under this. So, you know, breaches are more than just about losing personal data, and within that definition, doesn't, you know, accidental is a breach, and nobody, I think, sets out to deliberately lose or destroy data unless they're subject to some sort of attack, cyber attack.
I'm gonna make a little parenthesis there. It doesn't need to be, as you say, it could be like an honest mistake. And this honest mistake, I want to put a perfect example that I saw in a lot of companies. Is like, it would be a data breach if you put in a POSIT near to your computer, for example, your user and your password. That's a data breach that it will be. An attacker can use it to gain access to. So even though we have to be really careful about, as Jeremy said, how we treat this data, and how think about a little bit how we have access to it, and also be careful with these little mistakes, because even though it's like something little, like a POSIT in the that you are gonna see, or maybe your colleagues they are gonna see it, but it's critical. So yes, even those little mistakes that can be lead to a major problem.
So don't share passwords, remember your passwords, come up with something that you can remember that will be unique to you, and make it challenging for other people to guess what it might be, I guess.
Yeah.
Yeah. Good stuff. So what is a personal data breach then? So GDPR introduced a duty to report certain types of data breach. So a data breach can be broadly defined as some sort of security instance that has affected confidentiality, integrity, or availability of personal data. So in shorthand then, a data breach will occur when data is accidentally disclosed to someone who doesn't have permission to view, which is just what we were talking about. Somebody's seen on a post-it note your kind of password. Someone accesses the data or passes it on without proper authorization, and that's what's got some companies into hot water. They've sent data out without sufficiently thinking about the ramifications of third parties being able to see it and access it. Or the data is either maliciously, as Alvaro's been talking about, or even accidentally unavailable, albeit temporarily. It's unavailable, it's corrupted, it's got lost, it's destroyed, until you can do your backup. That's all under the auspices of GDPR, a breach. So examples of data breaches, just building on that then, it's like an authorized third party has gained access. Personal data is either accidentally deleted or disclosed. We've sent personal data to an incorrect recipient, so not the intended recipient, or we've put it into an environment where other people may be able to see it. Computing devices containing personal data being lost or stolen. Those of you who I've trained before know that before I came and worked with IFAC, I was working with Nationwide, and Nationwide copped for a multi-million-dollar fine because a laptop was left on a train which had personal data on it, and it was an 8-figure sum, that particular fine. So not just computers and laptops and tablets, but also things like memory sticks. Make sure they're encrypted, make sure that you don't really transport them unless you really have to, or any alteration of personal data without the permission of the person whose data it is. So as with any security incident, you should investigate whether the breach was a result of, say, human error, which is probably normally the case, or a systemic issue. I think most of us these days have probably tried to iron out systemic issues, but how recurrence can be prevented. So I'll just pause now for Alvaro to come in.
Oh, yeah, no, I was going to emphasize what you said. 90, I will say 95, 90% of these data breaches is for human error. As you said, like someone left a pen drive, or you give the information to the wrong person, like in a pub when you are sharing a pint. But yeah, 90% of this problem, 95% is human problem, because we have to think that the weakest point in the cybersecurity chain in a company, or even in your personal daily life, is the human, is yourself, is the one who is easy to attack through engineering techniques. It's easy to commit errors. So these kind of things is more the way to try to cut them is giving training. And as Jeremy said, like, thank you all for coming and be part of that training, because if not, like, these kind of errors, it will be going on and on and on.
Yeah, brilliant, thank you. So in terms of awareness then, so yeah, we talked about the data controller earlier on in the workshop. So the ICO considers that the controller has become aware of a breach when the controller has a reasonable degree of certainty that a security incident has occurred that has led to personal data being compromised. And if a data processor suffers a breach or is aware of a breach, they should notify the data controller as soon as possible. So if you do use an external processor and the firm that you're working with, the data processor suffers a breach, they have a responsibility to inform you without undue delay as soon as they become aware. In turn, you must notify the ICO, and the requirements around breach reporting really need to be detailed in the contract between you and your processor. And I'm sure that you've all got the I's dotted and T's crossed in that regard. So we've talked about notifying the ICO. Now, we don't have to notify the ICO about every single data breach. Now, what you need to do is you need to do an assessment, kind of a risk assessment on the likelihood and severity of the resulting risk to something that's very grandly called the individual's rights and freedoms. Now, unfortunately, there are no specific rules on this. So in essence, we've got individuals whose personal data has been compromised, and then they've potentially suffered either emotional distress because that information is now out in the public domain. Remember, this is broader than financial services. Or we can demonstrate there's either been physical or material damage. So as the data controller, what you need to do is any breaches need to be assessed on a case-by-case basis, and all those relevant factors need to be considered in terms of what's the severity, really, of the risk to individuals' rights and freedoms. Where you believe that it is a good idea to report to the ICO, as Alvaro said, if in doubt, definitely get it reported. Don't sit on it, get it reported, and then you'll be discharging your obligations. But once you become aware of a breach that you believe should be notifiable, you've got 72 hours after becoming aware of it to notify the ICO. And I would suggest that, again, the firms I work with would look to do that well within that time frame. In the unlikely event that you take longer than 72 hours, then you must give reasons for the delay and when you expect to submit more information to them. And there's no need to delay just because you haven't got all the information in place. Now, the ICO are quite realistic in this respect. So they know it's not going to be possible typically for you to fully investigate a breach within 72 hours and to understand exactly what it is that's going on. So report the breach and then provide the information that you get and glean in phases as you go along, and make sure you do it without undue delay. So once you become aware of it, assess it, understand it, interpret it, send it off to them. Any report should specify, exactly what's happened, who's been affected, and most importantly, what you're doing to mitigate the impacts of that and what your plan for resolution is. Yeah, and I'd build on that by saying, and to ensure that it doesn't happen again. So as data controllers, you're expected to prioritize any such investigations and give it adequate resources so that you can really put the pedal to the metal, as it were, and get it urgently resolved. So as I said, not every breach needs to be reported. It's down to you having to use your judgment, use your wisdom, and you say, right, okay, so what's the likelihood and severity of risk to individuals? What are the potential kind of negative consequences of what's happened as a result of the breach? And how severe are these? How likely is it that this scenario will actually play out and happen? If you are ticking both those boxes, yeah, it is severe and it is quite likely to happen, then report it to the ICO. But, if in doubt, report it anyway. You don't need to report every breach, though. So if it's a relatively minor breach, you might decide not to report it. And that's absolutely fine. Don't run away with the idea that every breach has to be reported. But if you decide not to report it, just make sure that you've documented why why you've not done it and justified your decision not to. So in terms of some of the factors you might consider when doing that assessment, what is the breach? What's occurred? What's the nature, sensitivity, and volume of personal data? Are we talking about 1, 2 people, or thousands, tens of thousands of people here for some of the big businesses that this impacts? Remember, the whole thrust of data protection GDPR is to protect the rights of individuals, and we talked about personal data. How easy would it be as a result of this breach for others to identify the individuals who are impacted on this? What is the nature of the breach, whether it's accidental or whether it's a result of a cyber attack, where we read about it in the press from time to time, don't we, where companies lose things like bank accounts, credit card details to the cyber attackers. What would be the potential severity of the consequences? Yeah, and are there any special characteristics that we need to consider, both in terms of those whose data has been breached and the firm that we're working as the controller? If there has been a breach and you believe it ticks all the boxes in terms of severity and consequences for the individual, then quite rightly you would deem it high risk. And when it's high risk, then you need to really get on to those individuals, inform them immediately without delay by using whatever mechanism you believe is the right mechanism to get in contact with them quickly. One of the key reasons under GDPR for that is to make sure that an individual can take steps to protect themselves from the potential effects of the breach that's occurred. So whether or not you decide to report breaches to the ICO, you should always investigate them and record them. So GDPR requires you to document the facts relating to the breach, its effects, remedial action, and corrective steps you're going to take, i.e., maybe some additional training. Yeah. Even where you're not going to report it to the ICO, I'd suggest that that's very much a template for best practice, so that at any point in the future, if challenged, you've got a robust kind of evidence that you have fully investigated the breach and you've taken steps to make sure that it's been mitigated and won't occur again. And of course, this is part of your overall obligation to comply with that overarching accountability principle. And importantly, it allows IFAC on your behalf to verify that you're compliant with the notification duties under GDPR. So it's kind of a must do from that point of view. So thinking about the documentation then, whether you're notifying it or not, get the facts down, what's actually happened here, what have been the effects of it, and what are the steps that we've taken to remediate the situation. As I say, that means you can meet your accountability obligations and allow IFAC to support you in that process. If for whatever reason you fail to notify, and I can think of no good reason why you would do that, as I say, just to reiterate here, it's fairly swingeing, eye-watering numbers. 20 million euro, 4% of global turnover. None of us want to be looking on the downside of a 17 million pounds sterling fine. So if in doubt, let's get it reported. And that fine can also be combined with other corrective powers that the ICO have got. So I guess we're all getting the message now, even if there's a suspicion of a breach, we should investigate it fully, and I guess 9 times out of 10, even if we aren't required to, think about just getting that reported into the ICO. Therefore, it's important that you've got a robust breach reporting process in place to ensure that A, you can detect a breach, B, you can notify a breach on time, and C, provide the necessary details surrounding the breach. Okay, so at the start of the session, about an hour ago, we said we got a number of learning objectives we wanted to hit. We were going to look at the context for data security, and we said, you know, data is the new oil. We looked at some of the key terms around data protection, data controllers, data processors, etc., etc. And we looked at what constitutes personal and sensitive data, information that can either be used to identify an individual or used to discriminate against them because of bias. We then drilled down into GDPR. We looked at 7 elements, the one overarching element of accountability and governance, and the 6 sub-elements within that. And latterly, we looked at how to remain compliant within the GDPR regime and looked at data breaches and how to report them. So all told, hopefully, what with the support materials available on that, this session, which will be available from Monday afternoon, you'll feel confident to sit and pass the IFAC test. So it's easy to find the resources if you just go onto BAT in the normal way. Look in the documents there. There's a whole section on GDPR. And then when you feel ready to take the exam, if you click on the T&C section, and you can find the financial exam under GDPR there. And again, there's some support materials to help you through the exam, multi-choice exam, no problem at all. And then finally, you do get CPD for attending this seminar. IFAC members have your attendance automatically logged onto BAT. BAT users must complete something called the reflective statement to get the CPD to be finalized. And I've given you an example of the reflective statement there on the right-hand side. IFAC also send out CPD certificates via Eventbrite for all attendees, including non-IFAC members or BAT users. Anyone not registering via Eventbrite will need to put the CPD into BAT themselves. Okay, so hopefully that makes sense. Charlie, is there anything you would like to add to that explanation of how people would generate their CPD certificate?
I think Charlie is not in a call. Maybe he has something, came up something.
Okay.
Yeah. I want to make a little note here is a lot of people and a lot of companies, they see the ICO as a punisher that it will, if you commit any single error or you allow any single data breach security is going to put you a fee. But please don't think about that. I have a lot of work colleagues in my field that we have the same problem. Like a lot of companies, they don't notify the ICO about these data breaches, even though they are not affected. But they are not affected in a really important way. But don't think about that. Think as a way to improve your system. Also think about help from the ICO, because the ICO is gonna guide you, point you what it should be done, what do you need to correct, and don't feel ashamed to report it, because a lot of the times, like a lot of companies, they don't report these kind of things. First, because of the fee. Second, because the shame and the negative publicity that it will receive from the users. But it's better to protect your company reporting to the ICO, showing a good practice and showing that you are willing to amend that accidents.
Okay, brilliant. Thank you very much. So with that in mind, for those of you who are booked on to the supervisor training next week, look forward to seeing you then. It'll be a bit longer next week. We're going to be nudging towards the 2-hour mark. But in the meantime, have a brilliant rest of the day. Have a great weekend. And we'll see you next week for some more IFAC training. Bye for now.